The Supreme Court is expected to hear arguments on Texas's new law, which bans most abortions. The case will be heard in just 10 days. The expediency of the case is unusual, as the law has been in effect for only a few weeks. The justices will decide whether the federal government has the right to sue over the law. Currently in Texas, abortions are illegal once cardiac activity is detected. This usually happens around 6 weeks into the pregnancy and typically before women know they are expecting. The Supreme Court is set to take up a separate abortion rights case on December 1st, which is seen as the most significant challenge to Roe versus Wade in 30 years. For more on all this, I want to bring in CBS News legal contributor Jessica Levinson. She is also a professor at Loyola Law School. Hi, Jessica. Great to see you. So how is this going to play out before the Supreme Court?
As you said, on an expedited basis, it's extraordinary for the court to say you are going to have oral arguments in 10 days. And actually, I was kind of startled when you said it because I kept thinking, oh, November next month. This is so quick. At this point, you would see the court setting oral arguments for the spring. So the court is indicating that it really wants to hear this challenge and it wants to dispose of it quickly. But I think what you said in the introduction absolutely bears repeating, which is it's not deciding the big constitutional question here. It's not deciding whether or not Texas's law violates Roe v. Wade and Planned Parenthood versus Casey. It's deciding who can sue in federal court to decide to block Texas's law. And that could determine how we go forward with this case.
So interesting because, of course, it doesn't get to the heart of the matter, really. So, Jessica, this is not the only case the Supreme Court will be hearing, though, on abortion. The justices will also hear a dispute over that Mississippi law that bans abortions after 15 weeks of pregnancy. Can we expect these two cases to have a similar outcome, or will they be different because of the reason you just outlined, that one is about whether the federal government has the right to step in here?
Well, I think that what you said in terms of this won't get to the heart of the matter, the answer is no, because the court knows in about 30 days later, it will be hearing a case that gets to the heart of the matter if the matter is where do abortion rights stand in this country? How restrictive can states be when it comes to limiting abortion rights? So the Texas law, as we said, will really answer the question of who can sue to try and block enforcement of the Texas law. Can it be the Department of Justice? Can it be abortion providers? And then the Mississippi law will kind of answer the second question, which Texas has actually asked the Supreme Court to consider in that case. And they said, no, thank you. They're really waiting for that Mississippi case, which asks, can Mississippi have a law that bans abortions after 15 weeks of pregnancy under the current understanding of this court? It would overturn Roe v. Wade and Planned Parenthood versus Casey. You cannot square a law that says no abortions after 15 weeks with that precedent. But what I think we should be looking for the court to do is perhaps uphold Mississippi's law. Say something like we're upholding the essential part of Roe, which is there's a right to obtain access to an abortion in the Constitution. It's just narrower than we thought. And then maybe take a look at or give us some guidance about laws like Texas that are even more restrictive than the Mississippi law.
So do you think then that justices plan on making a decision about the sort of permanence or impermanence of Roe v. Wade?
I think they have to at this point, only because they decided to take that Mississippi case. If you're comfortable with Roe v. Wade and Planned Parenthood versus Casey being the law of the land, then you don't accept the Mississippi case at all. You just say, no, this isn't permissible under our current law. Now, it does only take 4 votes to decide to hear a case. But if we look at what the court has telegraphed to us in this Texas litigation, they've allowed the Texas law to remain in effect while it's hearing these procedural questions. I think it's inescapable that there are at least 5 members of the court that are waiting and able and want to really narrow or completely overturn Roe v. Wade.
Now, that would be quite extraordinary, though, correct? Because that is a law with 50 years of precedence at this point.
It would be absolutely extraordinary. Now, one thing to note, of course, Roe v. Wade, yes, that is a half-century old precedent, but really the law we operate under is a case that I've mentioned before, the Planned Parenthood versus Casey that comes from 1992. In that case, they said, well, we're upholding Roe, but they really changed the framework. So that case is what we're operating under now. And that says to states, okay, you can restrict a woman's access to an abortion pre-viability, which is about 24 weeks, but don't throw up any undue burdens on a woman's ability to do so. And so what we've seen for the last, since the early 90s is a lot of litigation about what is an undue burden. This, as you said, this is a huge shift. It would potentially, just be seismic in terms of how differently we think about the constitutional right to obtain an abortion in this country.
Jessica Levinson, thank you so much for joining us. We will all be watching the Supreme Court very closely on both of these cases. Thank you so much.
Thank you.